it is 2 o'clock. We are going to go ahead and get started. My name is Harley Moore. I work with the Native Agricultural Financial Services. Today we have with us Mariel and Ridge. Ridge will be our presenter. So I'm going to talk a little bit about the funding and how we're able to host this webinar and this webinar series. Then Miss Mariel will introduce herself, and then we'll let Ridge introduce himself, and then he'll go into the presentation. So I'm going to do a little bit of housekeeping. We are recording this webinar. We will be posting the webinar on our YouTube channel. And then as soon as the webinar is downloaded and uploaded onto the YouTube channel, I will be sending out an email with a link to that recording. So you guys will have a link to that recording and more than welcome to share it with anybody that you think would benefit from this webinar. So today we'll be talking about legal risk management. This webinar series is funded through the Extension Risk Management Program, and we are very thankful to be partnered with the Farmer Veteran Coalition on that. And I'm going to, at this point in time, be watching the chat box and the Q&A box. If you guys have any questions, feel free to put them in there, and I'll make sure that Ridge addresses those questions in the middle of the presentation. But at the very end of the presentation, I will promote everybody to allow everybody to utilize the talking portion of a webinar, and you can ask questions if you feel more comfortable to ask them that way. That will happen at the end of the webinar. And so at this point, I'm going to let Miss Mariel introduce herself.
Thank you, Harley. My name is Mariel Kisnick. I work for the Farmer Veteran Coalition. So if you are a veteran on the call or listening to the recording, reach out at farmvetco.org. And our mission is to mobilize veterans to feed America. So any resources with education, finances, and just getting you set up for success in your farming career. And that is what we are here to do.
Thank you, Mariel. Like Harley said, my name is Ridge Howell, and I am legal counsel for Native Agriculture Financial Services. Today, we're going to continue our conversation about legal risk, and we're specifically going to look at agritourism and farm transition planning. So, how do you transition from owning and operating your farm to maybe passing it on to a family member or somebody of the like? Even though I guess I should start with the disclaimer that even though this is a legal risk management webinar, and we are going to be discussing some legal topics, none of this is legal advice. It's just simply a way for you to hopefully help think about your operation or your value-added business and ways that you can effectively plan to have, no legal issues come up during the course of your operation. I will go ahead and share my screen. We can get started. Okay, so starting out with an agenda, we're going to kind of be in two categories today, legal risk and agritourism. And during our discussion of that, we're going to look at zoning, tax considerations on your farm, and liabilities on your farm, specifically looking at things like a value-added business that you're bringing on. And then in the second half of the presentation, we will go into farm business transition. So what it looks like, as I said, to kind of transition your farm or operation from your ownership to the ownership of somebody else. And we'll really be looking at what happens if you don't have an estate plan, and then a couple of different ways that you can utilize the legal tools of wills and trusts to successfully transition your business. So getting started, land use, legal risk, and agritourism. The presentation will review a few of the items that producers need to explore when considering a value-added or agritourism business. The first issue you will face is the potential for land use restrictions of zoning. Zoning has the potential to prohibit producers' planned ventures outright. In other scenarios, zoning may require a producer to seek a license or a permit. Regardless, understanding zoning ordinances where you live is crucial to the success of your venture. After we generally discuss zoning, we'll explore three big areas that you should be aware of for your agritourism business, and that is tax obligations, the farmer ranch's obligation to accommodate people with disabilities, and then some food safety and food permitting topics. So picture this. You have a successful farm or ranch operation, but you want to build another revenue stream to complement the production of crops or livestock. You are thinking through some options like these: hosting a farm or ranch tour, offering some type of agriculture class on site, creating camping or hiking experiences, or having a pumpkin patch, opening a petting zoo, making preserves from your fresh produce, turning your meats into meals, opening a farm stand, offering farm to table meals, or building a wedding barn or facility like that for family reunions or events. But as you're thinking about these, you start seeing different kind of scary headlines about agritourism, such as pumpkin patches versus rope courses. Fairfax County battles farmers over agritourism. Barn weddings in the zone. Fights over farms, parties, and new suburban houses. Essentially, different things that make you think twice about adding a value-added business on your operation or opening some type of a facility for events. But you still want to continue. So, how do you plan around those potential conflicts? I think the best place to start is asking, what is your desired outcome? Is it simply that you want to better utilize all the resources on your operation and you want to build a new income stream? Do you want to meet the needs of tourism or a larger community in your area? Are you trying to transition from what you are doing now into a new line of work? Maybe your farming is becoming a hobby while the bed and breakfast that you want to start is really taking over your priorities. The second question you ask is, are there activities that you want to do that are somehow regulated by law or by ordinance in your area? And likely the answer is it depends. And it often depends on the zoning code where you are located. So kind of initially thinking about zoning, what is the what and why of zoning? Agriculture areas and the countryside have long been regarded as pretty quiet, low traffic communities. Noise, cars, scenic interruptions of an agritourism or a value added operation have the potential to disrupt the expectations of community members. And the reality comes in that where new ventures alter existing traffic, noise, odor, dust, and view patterns, neighbors have come to expect problems can develop. So, what is zoning? Generally, zoning is a system of land use regulation that controls where and how specific activities may occur in a community. Municipalities, counties, townships, and in some cases, tribal governments write and enforce zoning codes. Zoning codes are generally composed of two elements: maps, which divide the community into zones, and text describing the regulations relative to each zone. And then typically some form of a list of permitted and prohibited activities. For instance, some codes provide a description of what may occur, such as concerts. Other codes describe activities that are prohibited, like saying concerts are not allowed in certain areas. And other codes describe the end result that must be achieved regardless of the activity type that causes the result. For instance, operations that result in noise exceeding 70 decibels are not allowed. Most codes, however, also describe which activities require a permit before they are allowed. So generally your zoning code is basically your toolbox or your guide to safely and within the confines of law run your agritourism or value-added business. Understanding the zoning code. So if you own or manage a farm, having a really familiar relationship with your zoning code in your area is important. Even farmers who aren't planning on bringing some type of value added or agribusiness on to their operation, in addition to the production of crops or livestock, you still have something to gain from understanding the code. And it could be as simple as, how many animals may be housed on a piece of property, where buildings may be located on your property, and what types of events you can host. Of course, if a farm hopes to conduct any agritourism or value-added operation, the code's restrictions are essential to a strong plan, as zoning codes that give wide berth to agricultural operations often restrict tourism or value-added ventures. So it really is something that you want to think about together. So importantly, you're learning about zoning and the fact that you might have your own zoning ordinance that you need to comply with. So how do you find your zone? Knowing where and what type of community you live in can help direct where you should look for a zoning code. For instance, some states are organized by municipalities or local governments. And if you live in a municipality, you should probably first look at that municipality for the zoning code. Other states, like Maryland, for instance, have land use planning commissions that administer zoning in unorganized territories. And in other scenarios, individual counties may have elected to zone or may not have elected to zone. Thus, it's possible that no authority has enacted zoning for your property. I know me, for instance, I live in Tulsa, Oklahoma, and the majority of Oklahoma is broken up into municipalities. So that would be the first place I looked if I was looking for the zoning code in Tulsa. So you've determined there isn't a zone or ordinance prohibiting what you want to do, or you've at least found a way to do what you want while not violating the zone or ordinance. Now what? What other laws or regulations might come into play for my value-added or agritourism activity? Big pause, taxes. The basics of sales tax on the farm is one of the most important things you can understand if you are looking at agritourism as another branch of your operation. Although the sale of raw agricultural product is generally exempt from sales tax, that exemption does not extend to the farm as a whole. Farms may need to collect and remit sales tax for tickets, event admissions, processed products, and food that is sold ready to eat at the on-farm activity. If the farm is obligated to collect sales tax, the process begins by registering with the State Department of Revenue for a sales tax permit. You'll also need to determine what your local taxes might be. Income taxes and farming. When it comes to federal income taxes, the IRS treats farming activities and non-farming activities differently. For instance, farming or ranching activities include growing and harvesting crops, raising livestock or poultry, and preparing unmanufactured farm products for market and delivery to market. As a rule of thumb, work done on a farm in connection to farming operations is farming. Activities done on a farm that are tangential to farming and activities conducted off the farm are generally considered non-farming activities. Farmers are therefore required to report income and expenses from non-farming activities and farming activities separately. Farm income and expenses are reported on the Schedule F, profit or loss from farming form. Non-farming income and expenses are reported on the Schedule C, and the profit or loss from these activities, whether farming or non-farming, is then carried to the income section of the Form 1040. Let's walk through an example with somebody we're calling Farmer Jane. We have a farmer named Jane, and in addition to selling veggies and apples, Farmer Jane makes and sells cider and dried apple rings. Activities associated with making and selling the cider and drying the apple rings are not farming activities. Any income and expenses associated with Jane's cider and dried apple ring venture would therefore have to be reported on a Schedule C tax form. How do we report income for Farmer Jane? How would she account for this when reporting income and expenses for her value-added venture? The value of the apples before processing would be treated as a sale on a Schedule F and a purchase on a Schedule C. Expenses associated with the production of the apples would be allocated to a Schedule F, Expenses associated with the processing of the apples to make the cider and dried apple rings would be allocated to a Schedule C. Any expenses associated with the general marketing and delivery of her products could be allocated between Schedule C and F based on sales percentages of the respective products, i.e., veggies and apples would be on the Schedule F, and cider and dried apple rings would be on the Schedule C. Uh, Thinking about income tax on your agribusiness operation, accounting for the associated revenue and costs for value-added and agritourism ventures can be pretty intricate. Farmers with diversified operations are really in a position where you should consider seeking advice of an accountant or even a tax attorney before filing tax returns. One of the best places you could go when considering this is the IRS publication 225, which is the Farmer's Tax Guide. After our presentation, we'll send out a PDF of this as well, just as something that you could have either printed out or as a saved document on your computer, just because it's a great rule of thumb to check it, especially whenever you've got a diversified operation. But whatever you do on the tax front, probably the most important thing is that you keep great records. You need records and receipts when it comes tax time in general, and especially if you're in a position where you're audited. So what are some other important considerations outside of taxes and general zoning thoughts whenever it comes to agritourism? Things that are often overlooked include access to the location. So physically, how does somebody get from or get onto your property to start, the tour for your agritourism business, or start, picking apples or pumpkins in your pumpkin patch. So physical access to the location is important. Injuries to people when they are at your location. So somebody who comes on, let's say you do have some type of touring business on your farm, and what happens when somebody gets injured on that tour. Insurance coverage for your on-farm or agritourism venture, the importance of keeping good records, and then also food safety compliance. So a big consideration if you are planning some type of venture that's going to involve eating on your property. We talked about access to your location. I can't emphasize this piece enough. If you're looking at an agritourism business where people are coming physically to your location, you have to consider accommodations and taking action on the Americans with Disabilities Act, or the ADA. Apart from, just not wanting to be a operation that's known for not being welcoming, you also want to take the appropriate steps to make sure you don't have any legal liability on your farm whenever it comes to people visiting you. So similar to the tax guide, there's a wonderful ADA checklist that we will also include in our follow-up email with this, that offers, like I said, a checklist to help make sure you are reducing the possible barriers that people with disabilities might have when coming to or visiting your operation. And then finally, on the agritourism front, let's talk about food safety and food service, or more importantly, when you need a food service permit. Many farms are creating new opportunities to bring additional revenue and new customers onto the farm through different food services. This could be fancy farm-to-table dinners or a simple family-focused pizza night that are highlighting the farm's products in a starring role, where you're taking your fresh food from your farm and allowing people to maybe gather around a table and build a pizza together. So a wide variety of ways you could eat, but it's important to think about, I guess, that whole spectrum, because some farmers bring their expertise to the farm through catered food services, food trucks, and other opportunities that bring in professionals, while you might also just do it on your own. The important thing, though, is knowing when you are in the area of food safety and when you need a permit to help protect yourself. So, food safety permits, what and where? Food safety permits generally fall into three categories. The first category is a temporary permit. These are granted to food service events that cover from a day to 30 days generally. The second category, general category of food permits, is often called a mobile permit. These permits are given to push carts, food trucks, and other mobile facilities. For instance, if you had a wedding venue on your property and you have weddings coming in that are going to have some type of food aspect to them, such as a food truck, this would be an area where you would want to look into getting a mobile permit or perhaps seeing if that's the responsibility of the person who owns the food truck in your area. And then the third category of permits is often called a food service establishment permit. These are typically restaurants that operate in a physical location or on a regular basis. Then within these general categories, different states and municipalities all follow different naming conventions and standards for which permit is required for various types of food service ventures. However, as a starting point, contact the Department of Health and Human or Social Services in your state for specific information about food permitting where you are. In that same vein, what are some basic ideas around food safety that you should keep in mind for your agritourism operation? So even if you have a permit in your hand, you still have the responsibility as the host to exercise solid food safety practices. This includes things like washing hands in the field and elsewhere. For instance, if you have a some type of flower operation. You've got a business where people are coming onto your property to pick flowers, or maybe put together a bouquet. Are there areas where you need to make sure that you have a hand washing station? So when people go from the field to maybe the table, they have the opportunity to wash their hands. Toilet location and access for both workers and visitors, how you keep your surfaces clean and sanitized, making sure that foods are kept at appropriate temperatures. This is extremely important if you are at all transporting food. There are very specific regulations that guide what different types of food temperatures need to be kept at in order to safely eat. Making sure that your source foods from other folks who are exercising solid food safety practices, monitoring for animals and birds in the area and blocking off places or throwing away contaminated products, and then making sure you have a clean water source. And this often requires that you know about hazards and runoff issues in your specific area. Which brings us to probably my favorite phrase in the presentation, at least whenever it comes to food safety liability: you break it, you buy it. Now this is a generalization and you can't put it on every situation, but generally, if you invite people onto your property and you make them sick by the food you sell to them or serve to them, you are liable. You have to remember that foods are goods, and anyone putting goods into commerce or selling them are liable for the harms caused to others. So you must keep good records associated with your food handling and food service activities, because in the event of, a food illness, you'll need those records to help, corroborate your story if you're challenged or accused of making somebody ill or causing harm with your food. And then the same holds true if you're inviting someone onto your land for an activity, such as picking out pumpkins, riding horses, having a meal, etc., and they trip and fall or have some other bodily injury while at your farm or ranch or your agritourism operation. So, even if it's maybe not directly related, let's say that you have a guided horse tour. And before somebody ever even steps on the horse, they fall and injure themselves. that's still a scenario where you might be liable because they were injured while they were on your property engaging in whatever activity you had. On that, for specifically for horse-related activities, many jurisdictions have passed laws that limit the liability of operations where horses are involved. However, limiting your liability means that you have to A, know what those laws say, and B, fully comply with those laws. In other words, even though there are jurisdictions that have put some places in protection for, let's say, a horse riding adventure, those protections only apply if you are within the confines of what those laws say. So that could mean that you need to have signage and waivers at your operation, and each state or locality will likely have a different approach to limiting this liability. So again, it's an area where it's just good to check in your, let's say, county about what types of waivers are necessary. In other words, do your horse homework and comply. And then finally, for this part of the presentation, just other harms to keep in mind. If you've got an agritourism or on-farm activity that you are turning into a business operation, make sure there aren't dangerous pieces of equipment in easy access areas. Make sure children coming onto the land have contained areas for play, or even childcare workers keeping an eye on them. Um, Again, depending on what type of operation you have. Make sure you do not serve alcohol unless you do so under a strict regime of compliance with local and state laws. Like food compliance, alcohol permitting is extremely specific to the area that you're in. So you definitely want to check that before you have somebody coming on serving alcohol. Uh, Walk the property regularly. Take pictures that have a timestamp on them. Clean up hazards, fill potholes. Essentially make sure the areas that the public will access are as safe as possible. And then finally, carry insurance and decide today what happens to your operation after you're gone. Which brings us to farm transition. Before we start that, though, I do want to take a quick second and pause to see if we have any questions that have come through that I need to address Harley, or if we're good to keep going on to the next part of the presentation.
The only question that just came in was, is there FSMA requirements for agritourism?
Yes. FSMA, Food Safety Modernization Act, yes, there are FSMA requirements for agritourism. We're not talking about that specifically in this presentation, but if you want to follow up separately, that's something we would definitely be happy to talk about or point you in the right direction as far as resources go.
And I do want to remind anybody, if you have questions now, please feel free to put them in the chat or the Q&A box if you have questions.
Okay, awesome. We will keep going along then. So you've got a operation, whether it's a traditional, livestock or crop operation, or whether or not you're getting into agritourism or some type of value added business, you have a farm and you're looking at the options for how you transition this business. Where are you and where are you wanting to go? It's always the first question whenever it comes to transition planning, because it helps you figure out what you need and who you need to communicate with, which often includes your family and any other heirs to your operation. Generally, this second part of the presentation is going to look at tax consequences and estate planning, financial resources of the next generation. So any considerations you might have or might want to take into consideration today about whether or not, you know, your next generation are going to have the same access to finances as you do, the timeliness of the farm transfer, and then finally, how involved transferring farmers want to be in the operation of the farm and the continued operation of the farm. Estate planning for your operation. So estate planning can be a really simple or a complex process depending on the size and composition of your estate, your family situation, and your business situation. No two families have precisely the same set of circumstances. However, there are some basic estate plans that most people follow. These include joint tenancy distribution schemes, simple and complex wills, and trust. This brings us to the 5 Ds. Many producers fail to do adequate farm business transition planning, which is an issue if there's not a plan in place when one of the 5 Ds occur. Death, disability, divorce, disagreement, or disaster. 45% of those 55 years or older do not have an estate plan. And without a proper plan in place, one of the Ds could lead to land or even total farm loss for your operation. So what type of estate plans are available to you? Uh, this is a little funnier on the nose, but your first option for estate planning is to not plan. You could have no plan. This is common, though not recommended, to have no plan for your death and your estate. No will is written and little attention is paid to property ownership, estate distribution, or taxes. Each state generally has a succession law that dictates how assets are distributed if a person dies without a will, which is referred to as dying intestate. Accordingly, if you die intestate, state law will determine who will inherit your property. In most cases, it will be divided in some manner between your spouse and your children, if you have them, except for joint tenancy property and life insurance. Joint tenancy property will go to the surviving joint tenant, and life insurance will go to the named beneficiary. Things become more complicated if there are multiple marriages involved. A state's plan creates issues because they are generally complex and not flexible. It does not change as your family and financial situation changes, and it may provide inadequate income for the surviving spouse. This approach often results in unnecessary tax consequences and other consequences. This approach also generally leaves your family and operation without the ability to voice their desires. For farmers, the state plan may unfairly treat a farming or business heir if assets are equally divided between all heirs, and these issues can be prevented by establishing a will during life. After not planning, we can come on to joint tenancy distribution. Another common plan is to put all property into joint tenancy and to let the surviving tenant inherit all the property. When does joint tenancy work? This may work well upon the first death of a spouse with a small estate where the husband and wife hold all of their property in joint tenancy, or in other words, they hold all their property together. Many couples use joint tenancy ownership of the personal residence, personal vehicles, and the checking account. So when one spouse dies, the survivor gets the property without any kind of delay. What are the downsides of joint tenancy distribution? If the estate exceeds the federal or state exclusion amount and is the second death, this approach can cause huge tax consequences. The holding property in joint tenancy with children can cause other problems if the child dies first, or if the child gets involved in bankruptcy, divorce, or another adverse legal action. For some people, no plan looks like joint tenancy. For instance, before I went to law school, my parents did not have a will. However, in the case of death, almost everything would naturally flow to the surviving spouse, as they were joint tenants on almost all marital property. In other words, both of my parents' names were on all checking accounts, car titles, insurance, the pasture land that we owned, and our home, and on their cattle notes at our local bank. So for them, joint tenancy really ended up being a fine plan because they owned everything in common, but this is not something that is true for most family situations. So kind of what is the takeaway from a joint tenancy distribution scheme? Joint tenancy can work well for families with total net estates under the federal, state, and applicable exclusion exemption amounts. However, joint tenancy does not protect assets from adverse actions such as lawsuits. Joint tenancy does not avoid the probate process upon the second death of a spouse. And joint tenancy will not protect assets from long-term care costs paid for by Medicaid. So after not having a plan and joint tenancy plans, we then come to probably the biggest tool that people use in estate planning, which is a will. What is a will? It is a legal document which lists instructions regarding the distribution and management of your assets. A will technically directs finances only, with the exception of guardianships. So typically a will would only cover what happens with somebody's finances or property assets after death. However, wills can also include what the person who passed away, if they've got a child, what their ideal situation is for the guardianship. So you could dictate in your will who you want it to be the guardian of your child. And then a will is also usually the first step in an estate planning process. Who should create a will? Generally, spouses should each have a separate will. A will can be personalized with pretty great latitude, and it can take into account how your individual will is written. There's more than one type of will, and your life and financial situation should provide insight onto what succession plan works best for you. But this is really the place to start whenever you think about transitioning your farming operation. Wills, the simple or the sweetheart will. Many wills are written which distribute all assets to their surviving spouse. Sometimes these are called simple or sweetheart wills. This can be an acceptable plan if the total value of the couple's assets, including life insurance, is less than the federal and state applicable exclusion exemption amounts. In that scenario, no estate taxes would be payable upon the second death of the spouse. Most simple wills leave everything to the children equally if there is no surviving spouse. However, simple wills can cause issues when children are involved. Under both simple wills and joint distribution plans, leaving everything to your spouse gives no protection to children. A surviving spouse may spend or lose all the property, or may remarry and lose control of your estate, leaving your children with no part of your estate. Additionally, passing the assets equally to all children may not achieve goals for passing on your farm to the next generation. So, in addition to simple wills, we also have the complex will, which is where most people find themselves whenever it comes to creating a will. Complex wills are used to create a trust or structure for estate planning purposes. Couples who have divided their property ownership somewhat equally between themselves often use complex wills. Under a complex will, upon the first death of a spouse, this plan uses the will to direct assets to the children via a trust with life use to the spouse. This is used when combined estates are valued over the federal and state applicable exclusion exemption amounts, and when definite provisions wish to be made for the children. So a complex will, if you've got specifics that you want to attribute to a child or differently to children, this is when a complex will is really useful because you can tailor it a lot more specifically to what you want to how you want your estate to be handled after death. Complex wills continued. Any assets such as stocks, bonds, life insurance proceeds, mutual funds, real estate, or cash can be set aside for the children. Willing a portion of the estate to the children protects the children in cases where the spouse remarries or otherwise consumes the estate prior to death. It also prevents this portion of the estate from being taxed at the death of the spouse. However, this process does not necessarily protect the children's inheritance from lawsuit or other adverse actions. Special trust provisions must be put into place if you want that type of protection. complex wills also do not avoid the probate process upon the second spouse's death. So even though you've got a will, you still would have to probate it after the death of the second spouse, which can be time consuming and expensive for the family if it's not properly set out in the will. And then finally, we have the holographic will. Uh, Wills, while it differs by jurisdiction, a will generally must be witnessed by non-beneficiaries of the will and notarized. This can lead to timing issues, especially in emergency situations. In these scenarios, a holographic will can provide a family with some ability to make transition plans. The holographic will, it's really useful because there generally is the witness and notarization aspect that has to be carried out for a complex will. But in states that allow holographic wills, um, it, this can be the workaround. And it basically is just an entirely handwritten will that is signed and dated by the testator or the person who's passed away. Crucially, the holographic will does not have to be signed or notarized, so it can be created in a pinch. Holographic wills are not valid in every state, and you may run into issues validating a holographic will during probate. Requirements differ between jurisdictions, but the following states accept holographic wills in some form. These states are Alabama, Connecticut, Indiana, Iowa, Kansas, Massachusetts, Minnesota, Missouri, New Hampshire, New Mexico, Oregon, Rhode Island, South Carolina, Vermont, Washington, and Wisconsin. So the holographic will can be a lifesaver in a pinch, but there are some downsides to it. You've got limited ability to direct transition, so it may be complicated in scenarios with multiple beneficiaries or when there are complex business ties. Holographic wills have the risk of legal challenges due to the lack of a formal witness or notarization. So basically, it can be a lot, you've got a lot or an increased vulnerability to fraud or claims of a lack of capacity. So there's just not as much protection for the person creating the will because they don't have that formal witness and notarization. And holographic wills can be invalidated if not executed according to state law. Typically, state law, in states that allow holographic wills, they say some version of that the will must be entirely handwritten and signed. And oftentimes that entirely handwritten portion means that the actual sheet of paper that the holographic will is on can't have any other text besides the actual handwritten note of the person who created the will. So even, something as simple as a letter. Let's say you received a letter that had somebody's name and address on it, and on the flip side of the will, you wrote your holographic will and signed and dated it. There's a potential, especially depending on the jurisdiction that you're in, that there being any type of printed words on that letter could invalidate the will and mean that it's not accepted in court. So, wills, the good and the bad. Starting on the left column, what are the pros of wills? You can control property up until death. So if I created a will right now, I'm 29 years old, and it's hypothetically that will could last me until my death in 50 years. And I could do that because even if things change or my situation changes, I've got the ability to adjust that will during the course of my life. Uh, Wills can also direct who gets property. You can select the executor and guardians in your will. And once properly distributed, the will is no longer needed. So after it is properly sent out to the people who are keeping it, you no longer need it. The cons of the will, however, you have to probate a will. So even though you have it, your family will still have to go to court, or your heirs will still have to go to court afterwards to basically prove that the will was valid and it can be followed. Wills are easily contested, even if you include a no contest clause. So somebody who's disgruntled about, let's say, not receiving anything in a will, it's pretty easy for them to at least assert an initial challenge to the validity of the will. It takes time to create a will, typically, and if you're in a pinch, that can be an issue. And it's also a public process. So after you create the will, you have to file it, and it's something that can be viewed by the public at large. And then finally, wills are state specific. So even though this is, for instance, in this presentation, we've kind of gone over some of the high level pieces that compose a will. All of it's going to be specific to the state you live in because it's a function of state law. Continuing on, in addition to wills, we also have trust. Trusts are another succession planning tool. A trust can provide a means to hold and manage your property. You can think of it as a bucket in which you place all of your assets. While trust can be customized to the person, most trusts have four basic elements: a trustee, a trust property, beneficiaries, so people who receive the benefit of the trust, and then instructions and guidelines. Trust can be used for many purposes, including management of assets for minors, elderly persons, or handicapped persons, and protection from lawsuits and/or other adverse actions. Trust may be used to leave someone a limited interest in property or to transfer a farm business. They also may be utilized to reduce the size of an estate or to minimize estate and probate costs. Unlike wills, trust as an estate planning tool are not for everyone. Uh, this is a non-exhaustive list, but people who should consider using a trust include those who, with estates approaching the federal estate tax limits. For 2025, that includes estates that are valued at more than $13.99 million. And for an individual, and $25.84 million for a couple. Trust may be a good option for those with children or disabled family members. This is a way to provide for their care if the parents were unexpectedly to pass away. And trust may also be a good option for family members that can no longer manage their own affairs, such as an elderly parent. Testamentary trust. There are several types of trust that exist, but there are two main types: testamentary trust and living trust. Testamentary trust, which we discussed during the complex wills portion of this presentation, are trusts that are created by the grantor, the creator of the trust, as part of the last will and testament. The trust is established after the grantor's death. So it's created before, but it's established after. In the will, a grantor can separate trust for each beneficiary, splitting assets equally, or a family trust that allows assets to be distributed based on need or some other factor. Living trusts are different because they don't have to be probated. The process of validating a will probate. So trusts are different. Living trusts are different because they don't have to be probated after death, as they are created and active while the grantor is still alive. Living trusts are established during the grantor's lifetime and may continue after death. A living trust can either be a revocable living trust, which is changeable, or an irrevocable trust, which is unchangeable. Reasons to consider a living trust: you avoid probate costs, you allow for the transfer of property in different states, it allows for managing of assets if you become personally incapacitated, and it distributes property to the beneficiaries faster than the probate process allows. Reasons you might not want to consider a living trust: they are expensive to create and update. It requires a lawyer anytime to draft trust documents and to administer the trust. And oftentimes this means expenses outweigh benefits. Many couples who use trust today, though, prefer the revocable living trust as their primary estate planning tool. They choose the RLT because assets in an RLT pass outside the probate process, potentially saving the couple thousands of dollars. They would set up a joint or separate revocable living trust during their lifetime by placing all their assets into the trust. By placing these assets into the trust during their lifetime, in lifetime trust shares within the RLT. It protects those assets from any adverse actions, such as lawsuits upon the death of both parents.
Ridge, we do have a question. It says,
Yes,
what about a service for revocable living trusts like LegalZoom or others?
like, uh, are they asking if that is a good service that they could do to create a trust?
We'll see. It's James, if you can clarify. Oh, is it valid or does it still require a lawyer?
If it's a trust, it will require a lawyer because there's going to be there will be witnessing sections and notary sections, so it's not something that you could just do online on your own. But there are legal services that have real lawyers attached to them that provide, you might say, expedited wills and trust, or even they might even have options for low income or financially distressed individuals to create something. But if it's an actual trust, I can't think of a situation where you wouldn't or where you wouldn't have to have a lawyer, I guess, if that makes sense. Not necessarily the same for wills. I mean, the best example is the holographic will, which the beauty of the holographic will is that you don't have to have anybody else even in the room with you to create it, including a lawyer. But like we talked about earlier, the downsides to that are it's just a lot easier to challenge. Um, so yeah, I can't think of a scenario where you wouldn't be required to have a lawyer to create a trust. If you want to clarify the question, though, I'd be happy to answer it again in the Q&A part. Okay. Continue on irrevocable trust. These are also established during the grantor's lifetime, and they are used to reduce the size of your estate, thus reducing taxes, and or to establish a trust for beneficiaries. The irrevocable trust removes property irrevocably from your gross estate. Thus, placing assets into an irrevocable trust is final. Once they're placed there, they cannot be reclaimed, nor can the trust conditions be modified once it's established if it's a true irrevocable trust. So basically, once you place something into an irrevocable trust, there really isn't any legal function that you can call upon to take those assets back out. So what are the good and bad of trust? The pros on our left-hand column, it eliminates the need for probate. So there isn't an issue with proving that the trust was valid after death. Trusts are not public information. So if privacy is a concern of yours, or if your trust includes significant business information, this might be a really attractive attribute of a trust because it's not going to be openly available for the public to view and digest. They are very difficult to contest. Part of the function of the lawyer in a trust is that everything is basically set up into varying contractual relationships, and it's proved during lifetime. So there aren't questions about whether or not you really intended to create the trust after you're dead. And you do not need guardians to hold assets for a minor under a trust. That's one of the big benefits for people who are concerned about the well-being of their children, or perhaps incapacitated individuals in their family. You can set up all of those functions for those individuals during life through a trust. So it's really a lot of peace of mind for certain family dynamics. The downsides or the cons of a trust, you potentially have trustee fees. So if you have a trust that requires significant administration by the trustee, you are likely going to have to pay them some fee for their role as the trustee. It adds complexity to asset management. You need to coordinate with other estate tools. So I said your trust is kind of like a bucket that you place not just your assets into, but also instructions for how to carry out your assets, which requires, kind of a big web of estate planning tools that all need to be synced up in order to create the trust. And then finally, even with the trust, you still need a will. That's one of the basic functions of the trust is that it's based off of your will, which is the first place you start when you're creating the trust. So really good option for individuals or families that have either significant assets or significant liabilities. And it's also a great option for families that have maybe more complex family relationships where you are trying to coordinate care for others after your death or incapacitation. So it's a really good option, but it's just going to be more time intensive and it's probably going to cost significantly more than it would to create a simple will. So the summary and conclusion for our transition piece of this presentation. It's important to remember that no estate plan is, in fact, an estate plan, but one that might have unfortunate consequences. Success with estate and transition planning requires communication, not only within your family and your beneficiaries, but also with any outside parties like accountants or lawyers that are helping you with your transition plan. Estate planning tools discussed are only helpful once you know what your goals are. So go talk to your family. The best way to get started in these or in this conversation is with honest dialogue between yourself and your heirs. It can be kind of awkward at times for people to broach this subject because it does require you to kind of look death in the face to some extent and plan for what happens after you're gone. But it's one of the best tools that you can give to your children, especially, but to whoever your heirs are, because it leaves them with the ability not to fight or have, significant disagreements after your death whenever it comes to your estate. So thank you all for attending today. Um, we'll still have our Q&A session, but first I want to direct everybody to this final slide, which has 2 additional webinars coming up, one over human risk on April 17th, and then one over financial risk on May 15th. And if you want to take a picture of the QR code on the screen, that will take you directly to a link where you can sign up for these future webinars over Zoom.
Uh,
I will.
Mitch doesn't know this, but we do have an upcoming webinar, and a special edition webinar that will be March 5th. And I will be sending out that link when we do the follow-up email. And that special edition webinar will be presented by Mr. Rob Holcomb, and it will be over record keeping, the record keeping portion of taxes. He feels like with the end of tax season coming, he wanted to be able to give you guys a little bit more information than he was able to at the very beginning. Sorry, Ridge, but I wanted to put that plug in there. And we are trying to get a webinar over crop insurance scheduled for the 3rd Thursday of March. I will make sure to send out that information too. But I did want to ask if anybody has any other questions for Ridge before we pop off of here.
Today's words of wisdom come from Proverbs 30. Every word of God proves true. He defends all who come to him for protection. Do not add to his words, or he may.
Thanks for coming, Timothy.
Well, if you don't have any questions now, but you can think of questions later, feel free to send me an email, and I will make sure to get you in contact with Rich.
I also just added my email to the chat. So feel free to copy it and send them our way.
All right. Well, I guess we'll give you guys about an hour back of your time. Thank you, Ridge, for the presentation today. It seems like there was a lot of good input of everybody saying it was very informative and helpful. If you guys want to re-watch this webinar, I will be sending you guys the recording link. Feel free to share it with any of your friends and family. We're just trying to share as much helpful information as we can. Thank you guys again.